Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England.
Hi, welcome to FDA Imports, cross-border compliance with Benjamin England. And I'm Kendall Trusky, your host. Hi, Benjamin. How are you today?
Doing great. Very good. Good to see you and happy to talk with the audience about FDA and customs issues.
Wonderful. Looking forward to hearing about it and learning a few new things. I want to kick this off by asking you, can you explain the role of the FDA and the U.S. Customs in regulating imports?
Certainly. So customs is the agency that's responsible for everything that crosses the border, import, inbound or outbound, imports or exports. They're sort of a general agency. They're primarily focused on risks to the Homeland Security, right? CBP is Customs and Border Protection is an agency of the Department of Homeland Security. They also are responsible for collecting duty and for assessing duty for imported cargo, collecting the tax that comes in, and then making certain that the products that come in that are subject to trade agreements for some preferential treatment, or products that might be subject to like higher duty rates because of some sort of trade remedy that the government has taken against another country. So an example might be like that would be where another country is subsidizing an industry that our industry competes with, and the Department of Commerce may, with the U.S. Trade Representative, impose extra duties on those products from that industry, from that country, and then Customs enforces that by collecting those duties. So they're a general import agency. The Food and Drug Administration is a regulatory agency ensuring the safety and the quality and the efficacy, to the extent that it applies, of foods and drugs and devices and cosmetics. There are other agencies like that. U.S. Department of Agriculture is a good example, right? So because a lot of USDA regulated products come into the United States as well. So that's beef, poultry, eggs, pork. Those are USDA regulated as opposed to FDA regulated. FDA's responsibility is to make certain that they've got a system in place to screen information that comes in to verify whether products are safe, whether they're properly labeled, whether they have the various registrations or permits or certifications or licenses that they're supposed to have, depending upon what they are. And then whether or not they've been properly, they're coming from facilities that are registered and well known and recognized by the agency. They also have the responsibility to examine imported cargo under their jurisdiction, to sometimes sample and test it. Customs is the enforcement agency. Their responsibility is to whenever there's an FDA violation, FDA has some limited authorities themselves, but they don't have sort of the ultimate authority of keeping something out or seizing it, or even exercising monetary penalties for failures and violations. Customs has that authority. So the two agencies work together, where FDA is sort of the brains of the operation, right? And Customs is the brawn. And while FDA is evaluating these requirements, the information they're using is the transactional data, the Customs import transaction data that Customs receives and requires and transmits to FDA. So that transaction information has to be true also. You can't lie, you can't lie when you file your taxes. At least you can't do it legally. And you can't lie when you import cargo. And it's the same way. If you lie when you import cargo, then you're committing a violation. If you do it related to FDA regulated goods, then both Customs and FDA will care about that. But so that's how the two agencies sort of work together. One is doing the thinking and the other one's doing the muscle. They're the ones sort of, Customs is doing the work.
Very good with analogies. Let me ask you, how does the FDA inspect the products at the border? And is there a criteria that they use to determine if the imported product complies with U.S. regulations?
Practically speaking, FDA might examine just the electronic data, right? They may never look at it. They may never actually look at the label. They may look just the data alone. Mm-hmm. The data. So you import something, you're going to say who the manufacturer was, what the product is. You're going to the name of the product. You're going to have a harmonized tariff schedule code. That's the customs code that's used for a duty, for evaluating duty and other things. And you're also going to have an FDA product code, and you're going to tell all this information to the government. FDA might already have a history of a problem of that product coming from that manufacturer. So they may not do any examination at all. They might just take the data and stop the cargo and make you prove that it's safe. Okay, so there's no exam. That's actually a detention without physical examination, which is one of the provisions in the statute. So,
and they can do that?
Yeah, FDA can stop your cargo without examining it. Now, that's and they actually do a lot of that. They do that. You'll see these in FDA world. You'll see it in the import alert system. If you go onto Google or on the FDA.gov and just type in import alerts, you'll see the list of 250 import alerts for all sorts of products from all over the country, all over the world. So you want to make certain that your product is not, that your supplier and the supplier's product is not on that import alert. Because if it is, it's getting stopped coming in without even looking at the product. The other thing that FDA might do is they might actually physically examine the cargo. They might go down to the port, down to the dock, open up the container, actually go to the customs, to the warehouse. And they open up the container, or they tell the importer to deban it, get everything out, and they'll come physically examine the cargo. They might be looking for labeling issues. They could be looking for some sort of like infestation of insects. They could be looking for all sorts of things. Condition of the cargo. I mean, you think about it, this has been a big metal box coming across the ocean for the last 45 days. They want to see the condition of the goods. And then that might lead them to a sampling. They may sample the cargo. That's like a next step of an examination. In each of these cases, and then it's sampled and it's being tested by the Food and Drug Administration for whatever, whether it's insect filth or bird filth, animal filth, insect filth, or human filth. It could be, chemical contamination like pesticides, heavy metals, all the things we worry about our children eating, right? Foods that might have pesticides or heavy metals. Or they might be looking for salmonella or listeria or E. coli or some microbiological contamination. And then, of course, they'll also look at the label when they do that sampling too. Goes to the lab. That's a more intensive examination, but it's a form of an examination. And then FDA, if everything's fine, it gets released and FDA's done with it. If everything's not fine, then FDA will refuse the cargo. And sometimes FDA will work with customs to re-examine the cargo to make certain that it's actually leaving, right? So cargo that's been refused has to be exported or destroyed. And that has to happen under supervision, technically under customs supervision. But usually customs will supervise the exports of cargo that's FDA refused, and FDA will supervise the destruction of cargo that's FDA refused. They'll literally go down to the dump and watch you throw it in the dump to make sure that it got done. Yeah, so that's another kind of examination, right? That's a post-refusal examination to ensure that the enforcement mechanism worked. As far as standards, yes, absolutely. And you can find these standards. The FDA publishes most of the guidances that their field offices use for determining whether a product, sometimes you get that information about whether the product should be examined. That tends to be sort of in the black box. They tend not to reveal that information. But if FDA examines something, then there's actually a manual. It's the Investigation Operations Manual that tells inspectors how to do their job. And that includes how to inspect cargo, how many samples to pull, depending upon what you're testing for, the kinds of things that you're looking for in a certain circumstance. And then the other place where you get standards is from the regulations themselves, right? Like, what is the requirement with respect to a particular product? And so FDA's sampling or its examination is designed to determine whether or not those regulatory requirements have been met. So yes, there are standards, there is guidance. You can find it on the internet. The problem with trying to find it is that there's so much information at the FDA that trying to actually find the information you need can be complicated. So you might want to ask for help for that. Those are the types of examinations, and there are standards involved with that.
That definitely is necessary. And it kind of then leads us into what are some of the common mistakes businesses make that lead to FDA enforcement actions, such as the mislabeling or improper registration or documentation errors?
So there's two types of mistakes, right? One is sort of the innocuous, I made a mistake, right?
Mm-hmm.
And they actually could not be it might be they're not innocuous in terms of outcome, right? It could be that it's a serious mistake, but it was accidental. So that would be failing to declare an allergen on a food label, right? But if somebody's allergic to milk and you have dairy and you have milk in your product and you fail to declare it, it could be a real problem. So even though it's a labeling violation, it's actually treated as a pretty aggressively as an adulteration problem. And so FDA will actually usually force you to recall that. So the kinds of mistakes: one, not knowing what your requirements are for the product. Two, not documenting that you actually met those requirements. Three, not verifying that the facilities that you're operating with, right, the importers, not the importers, but the foreign suppliers, the manufacturers, the raw material suppliers, not ensuring that they know what they're doing, making certain they know how to manufacture a product safely, whether it's food, a cosmetic, drug, or device. Registration of an FDA-regulated facility almost means nothing. It's necessary, but it's so easy to do, it doesn't really mean anything. They don't vet. When I register, FDAImports.com registers a lot of companies all over the world with the Food and Drug Administration and acts as a U.S. agent for a lot of the foreign suppliers. But It turns out that registration is really nothing more than giving the FDA information about who you are and where you're coming from and what you're manufacturing. They don't approve the product. They don't even evaluate the product. They don't even evaluate you. You don't have to be inspected to be registered. You just have to, where a fee is required, pay the fee and give them the information. And that's it. So you have to have the registration. It just doesn't mean very much. So the fact that my supplier is registered is pretty meaningless. The question is, are they manufacturing the product in a way that ensures that it's safe or that it's effective if it's a drug or a device? And so that's much more substantive. Failing to do that is how companies get into problems. Failing to check FDA import alerts. I got a client right now, major retailer, bringing in product for Christmas, and turns out their supplier, cosmetic product, their supplier's on an import alert, just hit the import alert in spring, just as these transactions, the product was already on the water. And now all that product is jacked up. It's all jammed up, right? So not knowing the history of your suppliers can get you in a serious problem. And that's accidental. Like, no one's intending to bring in product that, the product actually may be fine. It's just they're on an import alert. So there's all these extra steps to get it in, and they weren't anticipating that in their supply chain. So those I think are some of the key things. And then being responsive to the government, not waiting around, meeting deadlines, asking for extensions. It's amazing. I have a case right now of a shipment that's been refused by the FDA because the importer changed the laboratory they were using, and the prior laboratory has in their protocol that they will request extensions of time, and the new one doesn't have that and didn't request an extension. And FDA refused the shipment just for failure to request an extension. The lab results came in and FDA refuses to look at it. So that's just like, not paying attention, not communicating, not talking to your broker, making sure your broker is doing their job. Those are the kinds of things that get people in trouble. And that's different than the other kind of violation, which is where people are trying to sneak something in that shouldn't be coming into the country. Completely different violation, completely different enforcement mechanism. The government agents that you meet will be of a different brand and a different style. And so FDA and Customs both have criminal enforcement authority. I was actually a criminal investigator with the FDA for 8 years in Miami. So I carried a gun for the FDA, which is you might imagine is the safest gun job in the country. But I was in Miami in law enforcement with FDA. And so we did a lot of counterfeit cases, a lot of smuggling cases, a lot of, we had companies that were buying salvage infant formula and then reselling it in the market, right? This is expired infant formula. So you name it, people will try it. If people are doing that, then they're gonna meet a different agency. It's still the Food and Drug Administration, it's still Customs and Border Protection, but it's not gonna feel the same when you're engaging those people.
Well, I don't think those people will be calling you.
Oh, it's funny. Usually they call me afterwards before to ask if I should do. They should do it. It's afterwards because I was in criminal enforcement, right? So, and people know that, and I'm known for it. So I actually do get a fair amount of cases that I bring in criminal defense counsel. I don't ever try to do it myself. But
that's interesting. Oh my gosh. Let's talk about what are some of the common FDA enforcement actions that importers should be aware of when they're importing regulated products into the U.S. and how severe can these actions actually be?
So I had mentioned previously, and I'll say again here, that FDA's authority at the border is pretty broad. The FDA doesn't have to actually prove a violation. They have to have evidence of the appearance of a violation, and they do that because, I'll just say, so that's the standard, right? That's the requirement. Now, the importer, in many cases, it's one thing to say, I have a system in place that's designed to ensure that I understand what my supplier is doing. I've looked at their manufacturing SOPs. I've even sent people over there to do audits and inspections so I know what's going on. It's another thing to know what's actually in the box when they ship something, right? So when I'm importing something, I'm at the mercy of the shipper. I don't really know until it gets here what's in the box, right? So the statute, recognize that that's true. And so it does a couple of things. It balances the FDA, the requirement that FDA has to protect the health of Americans from products that are being imported or domestically distributed. And at the border, the standard is lower. You only need the appearance of a violation to detain and refuse the shipment, which keeps the product from coming in the United States. The evidence standard is very, very low, but the remedy is also not very severe, right? Like FDA is not fining you money. They're not going to say, okay, now you owe me $15,000 because you imported something you shouldn't have done. The FDA is not taking title to the goods. They don't seize the cargo, right? When the government seizes something, they're taking title, taking possession, and they're going to try to forfeit it and take title. But the FDA law is not designed that way. FDA law is designed that appearance of the violation is very low, the standard, and the remedy is also relatively soft, right? The importer doesn't lose title. They lose possession because they're going to require to export the goods, but the government's not taking possession. So the only thing you have to do is you have to get it out of here, or you could choose to destroy it instead. It's up to you, but you got to do one or the other. So it's a balancing act, right? And now it's when you have repeat violations, or when you've got the kind of a problem with the product that the FDA expects to see that problem again with that product. And this would be a manufacturing problem, or a problem where there's a contamination with some bacteria in a food. If it's a ready-to-eat product, right? Something, let's say it's raw tuna, and it's and it's a sushi grade tuna, but it's got some contamination, or it's decomposed. A ready-to-eat food is going to be regulated more severely and more strictly than a food that requires further processing. And so if FDA finds problems that really represent a great risk to the consumer, then your future shipments are at risk of being stopped also. Okay. So that's an added enforcement mechanism. The government is not just dealing with this shipment, but they're also dealing with the next one when the goods come in. And that's where I mentioned earlier that the government can detain and stop cargo without examining it, right? If it goes on an import alert, the next time it comes in, FDA is not going to bother wasting resources examining that cargo. They're going to make you prove that it's good, and they're going to rely on the import alert to do it. That's technically, legally not correct, but that's practically sort of how it works. As problems increase, right? If you've got a repeat problem and it keeps going on, you can become what's considered what's called a recidivist, right? You keep having the same problem, and when that happens, the FDA can put the importer on an import alert and say, you can't import anymore. Forget your suppliers. So, right, the government can do that. It's pretty rare for them to do that, but they can. They could take your registration under certain circumstances. They could revoke a registration, suspend it or revoke it, which then prohibits you from operating in that industry until you get that fixed. So those are sort of the more typical. So now if I have FDA regulated cargo that FDA has refused, and customs is saying you have to get that out of here or you have to get it destroyed, one of the two, you have 90 days to do it. The statute gives you 90 days. If you don't get it done within 90 days, customs will go after your bond. Now, this is something I should mention. When I import product, it comes into the port of Baltimore, it comes into a seaport, or it flies into JFK, or there's a Peace Bridge up at the Canadian border on a truck. How does it get from the port to the next place, right? So the carrier is responsible for the cargo until entry is made, until customs receives the entry information. And then customs will release the carrier and allow the carrier to discharge the cargo to a certain person. That person is the importer. The importer, to get custody of those goods, the importer has to file a bond. They have to tell customs basically that the bond. It's just like, I'll use an example. If someone gets arrested and they go in front of a judge, and the judge is going to have another hearing for you later on. You come for the initial appearance and you get bail. You go to a bail bondsman. The bail bondsman will guarantee the court that you'll show up and you'll pay the bail bondsman a premium. So it's a $50,000 bond. I pay $5,000 to the bail bondsman. Bail bondsman guarantees the court that I'll show up. That's a bond. Exactly the same thing. When cargo comes in, I want to take the cargo. I only get to do that if I post bond. And the bond is going to be minimum $50,000. I pay a premium to a surety who guarantees customs that customs will get paid if I don't, if I violate, in the bail bond setting, I have to reappear in court. In a customs setting, I have to redeliver the goods if customs demands them back. It's literally the same kind of thing, right? It's a constructive custody of the goods. So this happens in every single shipment. That's how the stuff gets out of the port and gets into your warehouse that might be 50 miles away. It's in the United States, but it's not cleared yet. It's not released for commercial distribution, and it's under bond. If FDA refuses that cargo, refuses my cargo, I have to get it out of here, right? I have to export it or destroy it in 90 days. If I fail to do it, customs will go out against my bond. They will tell me, you either pay me the $50,000 or I'll go to the surety and get the $50,000 unless you can petition and convince me why I shouldn't take your money. Failure to export those goods or failure to redeliver those goods. That liquidated damage, that claim that customs can make is up to 3 times the value of the goods, the import value. So if I bring a container of lobster, frozen lobster, that's going to be worth $165,000. So So the customs, bond, the claim value of that is 3 times $165,000, so it's $500,000, right? So if FDA refuses it because they find salmonella in the lobster and I don't export or destroy it, customs can come after me for the $500,000.
Oh, wow.
However, my bond limit, right? I may have only purchased a bond and customs released it for $50,000. So customs can't go over the 50, right? They're capped at 50 just because of the way the laws are set. Customs has the ability to require me to pay more if the goods are worth more or I'm not trustworthy, right? If they don't trust me, they may make my bond $1 million bond, and that way they can get their money if they have a problem. So that's an enforcement mechanism that happens all the time. That's different than a penalty. A penalty is when I do something that the government believes I was at least negligent, right? I was negligent in allowing something to get in or failing to declare something correctly, or if it's more than a gross negligence or willful conduct, right? You can see the levels, right? Negligent, willful conduct. If Customs believes they have those kinds of evidence, that kind of evidence, they can seize the cargo itself, or they'll take possession, try to forfeit it, take title to the cargo, and also penalize me for differing amounts depending upon the different violations. Those are more like civil monetary penalties, which is different than, FDA doesn't have that authority. FDA doesn't have the authority to require the bond, to collect the bond. It's all managed through the customs system.
Okay. Benjamin, if I may ask you, what can happen to a business if the FDA decides to detain or even refuse entry to their shipment?
The detention means that the government believes actually that the amount of evidence FDA needs to detain a shipment is even smaller than refusal. Refusal is the appearance of a violation. That's what the statute says. FDA has issued a regulation that says if an article may be subject to refusal, then the FDA will give notice to the importer of the problem, right? That's the detention phase. But if you think about the language, right, may be subject to refusal. Well, we already know the statute says that articles are subject to refusal under the Food and Drug Cosmetic Act if they appear to violate the law. So when you put the two phrases together, you have if an article may appear to violate the law, right? That's pretty broad authority, right? That's almost like I was walking in a snowstorm backwards and I barely recognized the guy who was walking the other direction. It may appear to be Joe, right? I mean, that's like now I'm exaggerating, right? But the fact of the matter is, the government has to have evidence, and they have to be able to articulate that evidence, and it has to be rational, it has to be material, it has to be about my product, it has to be something that the violation is connected to the evidence that they have, so FDA will detain it. If they detain it, I have to try to get FDA to either change their mind, they're wrong. Which, by the way, I like to say the government is wrong more than always, because even when they're right, it's for usually the wrong reason. All right, so don't be afraid. I've had many circumstances where the government is just wrong in cases. There's also many times where the government doesn't understand the requirements, and that's why people hire me, is to sort of explain to the government, no, you must be mistaken on what this product is, because that provision doesn't apply to it. So at any rate, try to convince FDA that it's not in violation of the law, or it might be in violation of the law, but I could fix the problem. So I got to fix the problem somehow. Another option is to remove it from FDA jurisdiction, which is a sneaky one, right? This would be, I bring in something that is subject to FDA jurisdiction because it's intended for a particular use. But if I change that intended use that's not FDA regulated, they don't have the authority to refuse it. So I'm taking it out of their jurisdiction, and then FDA can't do anything about it. Now, I still have to get them to agree that I've succeeded. But those are the three things that I have to try to do to either get the product released or, try to get the product released, right? Because they're wrong, I fixed it, or I remove it from the jurisdiction. If I fail, then it gets refused. If it gets refused, then I have to export or destroy the cargo. Because I imported the product using a bond, which I discussed a moment ago, Customs is going to ensure that I get those goods out of here and ensure that I destroy those goods. And if I don't, they'll come against my bond, right? They'll take my money if I don't do what I said I was going to do, which is export or destroy. So those are the sort of basic things that are happening at the border around detention and refusal.
Well, Benjamin, this has been so very interesting to learn about. And how can businesses reach out to you or your team for further guidance and navigating FDA import regulations?
You can find me at FDAImports.com. That's the name of the company. It's the name of the website. It's a URL that's been around for a long time. So I like to say, if you can't find me, you're not looking for me. Just go into Google, type in FDA Imports. It'll be right at the top. Click there and you can go to the contact section, contact us, and just put an inquiry there. It comes right to my people. Or you can email me at any time, me and my team, through contact@FDAImports.com. And so you let me know if you're a manufacturer, foreign manufacturer, or you're a U.S. importer, or you're a customs broker, you're an e-tailer, you're a retailer, you're a distributor in FDA-regulated goods, or you're crossing the border with any of those things. Be happy to help you.
Great. Well, thank you so much. It's been such a pleasure speaking with you today.
Great. Thanks. Have a good day.
You too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.